Well, let's get some reaction to the crime and bail reform bill introduced by the Carney government. Niki Sharma is the Attorney General of British Columbia. She's also the Deputy Premier. Ms. Sharma, thank you for being here.
Thanks for having me.
Listen, I want to begin with a statement that you released through your office. And in this statement, you describe this crime bill as a, quote, promising step. Promising step. So where, in your opinion, is this bill lacking right now?
Criminal law is always going to have to be responsive to what's happening on the streets and what's changing in our communities. And we've certainly seen that. So I think that there's really good things in there. And I want to just commend Minister Fraser for the collaborative approach that he took. BC over the last few months has been providing our perspective on what needs to change in the criminal code. And I see a lot of what BC asked for reflected in the bill. I think there's more work to do with respect to Jordan stays, and I think there's a discussion about that coming, and intimate partner violence and how that shows up in our justice system. But there's some really good work that I think we were able to do together in a collaborative way that's showing up in the bill.
Well, you mentioned intimate partner violence, and the federal justice minister is promising to introduce more legislation later this fall, specifically to address gender-based violence. What are you hoping that will contain that might be able to build on the bill that's been introduced so far?
Yeah, we have a concerning rise in that type of violence across Canada. It's something that I think all of us are seeing in our jurisdictions, and I think it also a lot of Canadians were watching very high profile sexual assault cases that bring everybody through this journey about what it's like to take cases through the criminal justice system of sexual assault. And I think there's a lot of work to be done there. We've been examining the justice system in BC when it comes to sexual assault, intimate partner violence, to see why is it that people don't come forward with these types of claims, and when they do, what are the gaps in the process, and what can we do to make them go better? They're also one of the types of claims that are subject to Jordan delays, which is that timeline that just the trial just stops if you haven't done it within a certain amount of time. And because they're so complicated, they tend to take longer. So there's a lot of work to be done on that. And I hope that Minister Fraser will continue that collaborative approach that he's had with BC and other provinces to get to those changes.
And in the meantime, the current legislation does propose to expand things like the use of reverse onus for bail for high-risk cases. It also addresses post-conviction bail, which essentially makes it harder to get bail for repeat offenders and violent offenders. British Columbia wanted to see those changes, so I'm wondering from your vantage point, how would they make communities safer?
Yeah, this was a very particular ask for us related to a case that happened that was really tragic in BC, where, when a victim comes forward to say that I want protection of the system because of intimate partner violence, and in this case, it was Bailey McCourt, which was a high level of violence that she was experiencing. Her accuser was convicted. So the justice system found that beyond a reasonable doubt, the assaults happened. And at the time between conviction and sentencing, the individual was on an earlier bail order of release, and during that time, it resulted in the tragic murder of Bailey. And it made us look at the system when it comes to particularly these types of crimes, about how high risk it is for the victim once they come forward in the criminal justice system to ask for safety. So these rules that we asked for, my hope is it will tighten up the system, particularly when there's evidence of really serious intimate partner violence, to keep the victim safer, particularly during that time between conviction and sentencing, when there can be revenge and retaliatory thoughts in somebody that is, the violent perpetrator.
And I hear, as you say, you're trying to address a greater issue encapsulated by this one very tragic case. But we're still hearing from groups like the Canadian Civil Liberties Association. They strongly oppose, they say, the sentencing restrictions that have been outlined in Bill C-14. They oppose the bail restrictions. The organization, in fact, says that it is a myth that bail is easy to obtain in Canada, and that, quote, 76% of people in provincial and territorial jails are denied bail. What's your response to their concerns?
Yeah, you know what? I think that criminal law always has to balance certain rights, and that is a valid conversation to have all the time. Are we getting it right? From our perspective, there were certain types of crimes and certain types of offenders that the system wasn't filtering through in the right way. So every time you have a bail hearing, it's essentially a risk assessment. You're asking the court to say, before trial, and everybody's entitled to trial, what factors should we consider in what we do with this person before trial, whether they're held or they're released? And, innocent until proven guilty, very important pillar of our justice system. And with these reverse onus provisions, particularly from my perspective, for certain types of offenses on the accused or certain types of histories, so that the accused is really showing repeat types of offenses, which what we've seen in BC can lead to, escalation and harm to community if they're released, that instead the court should ask to the accuser, should you be held? And if you are released, what's the guarantee that there'll be safety, that you'll not reoffend? I think that's a valid question for the court to ask while they're doing that risk assessment. And that's essentially what a reverse onus is. It's putting the onus of showing that, the person should be released to the accused rather than the system. And it's important that it's for specific things, right? And one of the things is, in my view, is if it's for somebody that's shown repeat violence, somebody that's shown repeat offending and a kind of a disrespect for court orders or any other interventions that have happened at that time. We've seen some very specific and terrible cases where people that have shown this type of behavior have been released and they've reoffended. And I think there's something about also the fact that people have to have trust in the justice system and a respect for the justice system. And I think that when we see these high profile cases, there's an erosion of that. So what we were asking for, and some of those are reflected in these changes, is this concept of respect for the law, along with the principle of restraint, that if an individual is showing these continual breaches and continual violence, that the system needs to act accordingly. So I think that's kind of our perspective on it.
Niki Sharma, appreciate the time. Thank you for being here.
Yeah, thanks for having me.